welcome. My name is Malcolm Neekirk. This is Fretton's penultimate coffee break briefing of 2025, and I'm going to be talking about company resolutions for the next half an hour or so. I'm going to start by talking about the company rulebook and company constitutional law, and from there I'm then going to move on to talk about shareholder resolutions as being the way that shareholders make decisions on behalf of the company and which are binding on them as shareholders and members, and binding also on the company. And I'll be looking at the traditional way for shareholders to pass resolutions in meetings of the company's members. I'll be looking at the increasingly common modern way of passing resolutions by a written resolution procedure. And then the final point I'll be covering is how that works in companies that have got only a single member, and that single member may be the sole director of the company, or the sole member may be the holding company of the company. And that'll be the final point I'll be looking at. So let's get started by looking at the company rulebook and company constitutional law. There are a couple of sources of rules for the company rulebook. The most important one is probably the legislation. We're now on the Companies Act 2006, and one of the reasons why I've found it personally quite useful to put this refresher together is when I started practice, it was actually the 1948 Companies Act. I think it was the Companies Act 1948 to 81, which was quickly replaced by the 1985 Companies Act, which has now been further replaced by the Companies Act 2006. And hardly a year goes by without something being transplanted into the 2006 Act. So it is actually in many ways quite different now from how it started. The other important constitutional book are the company's Articles of Association. And the statutory model articles now are actually pretty good, and many companies simply adopt the appropriate model articles exactly as they are drawn. Some companies have bespoke articles or modified model articles, and if you find an older company, pre-2006 Act company, it'll probably be referring to the statutory Table A as the basis for its rulebook, with or without modifications. Other documents which are not statutory constitutional documents and not part of the rulebook of the company, but which can be very important nevertheless, are shareholders' agreements, which can sometimes make quite big changes to the rights that directors and shareholders have got, and investors' agreements, and I include loan agreements and debentures amongst those. And those can also contain restrictions on what the board of directors or the shareholders can do without the consent of the external investors. I put this slide together saying take advice if there was a conflict, with the intention of this just applying if there is some sort of a conflict between what the articles of the company say and what the Companies Act say. But I think actually it's got broader application than that. If you find that there is a conflict within the company, it might be a conflict between the directors, a conflict between the shareholders, or a cross between the board as a whole and the members as a whole. If there's a conflict of that sort, it can get very nasty, and you, in your role as an insolvency practitioner, really don't want to be drawn into somebody else's dispute, if at all possible. So do take advice on how to stay out of it, how to get the necessary objective achieved without being drawn into somebody else's dispute. Basic principle of company law, of course, is the separation of powers between directors and members. Members, of course, sometimes also known as shareholders or contributories, depending upon the context. And this is sometimes described as being an issue of hats, in the sense that you can have the same individual, can be both a director and a member of the company. But when they're making decisions, they need to be doing so in their capacity either as a director or as a member, and they should not be getting their status, their capacity mixed up at all. Directors are agents of the company. They've got the power to bind the company into contracts and other obligations. They've got the ability to delegate their powers to employees of the company, or indeed outsiders when it's appropriate to do so. They're responsible for managing the company, and that can be hands-on. They can actually be the day-to-day management of the company, or they might act in a supervisory role where the management report to them and they are there to represent the interests of the shareholders of the company. There are different ways of managing the company, of course. The main thing is that the directors should make decisions collectively as a board of directors. The members are effectively the owners of the company. They're usually financial contributors. They might have put all of their money in when they became a shareholder, or there might be an obligation on them to put more money in on some future contingency or date. The role that's reserved for them is effectively that of constitutional decision makers. It's not the job of the members to make management decisions for the company. That's for the directors. And when you need a decision from the members, the forum for them to make that decision is the general meeting of the company. By convention, most companies regard it as being the responsibility of the chairman of the board to represent the interests of the shareholders of the company and to be the liaison between the board and the shareholders. And of course, there's the general principle of company law that while a company is solvent, the interests of the company are equated with the interests of the shareholders. They're seen as having collectively the same interests as the interests of the company. They are seen as having a complete alignment of interests. If the shareholders have a particular interest, that is the interest of the company. Let's move on to look at shareholder resolutions, the decisions that shareholders themselves make. And there's a list here that are some examples of shareholder resolutions. At the top will be the ones that we'll probably have thought of first, which is appointing liquidators, putting the company into voluntary liquidation. And the shareholders can also pass a resolution to appoint administrators, which is described in the legislation as the company making the appointment, but it's the shareholders, the members, passing a resolution as a decision of the company to do that. Towards the bottom, there are some quite important ones in the context of the sort of misfeasance claims you might bring against directors. There are some transactions like directors' loan accounts and substantial property transactions with directors or their associates, which need a shareholder resolution to validate them. And without that validation, the transactions would be misfeasance by the directors and would potentially give you a claim against them if you were acting as liquidator or administrator, for example. Broadly speaking, there are two types of resolution. There are ordinary resolutions, which are passed by a simple majority of those voting, and there are special resolutions which are passed by at least a 75% majority of those voting. Now, the board can propose any resolution they want as a special resolution. If they think that they would want to act with that degree of support from the shareholders rather than a simple majority, they can propose absolutely anything as a special resolution. But there are some resolutions which can only be legally passed as special resolutions, and those resolutions, such as putting the company into voluntary liquidation, do require that 75% majority. And most resolutions require 14 days clear notice to the shareholders, whether those are ordinary resolutions or special resolutions. You may have come across in the past extraordinary resolutions and elective resolutions. Those do not apply to modern companies. Some older companies may have references in them in their articles of association to extraordinary resolutions and elective resolutions, but they're really not important. Here are some examples of the sorts of resolution that can only be passed as special resolutions. So changing the company's rule book in terms of changing its articles of association, that requires a special resolution. Putting the company into voluntary liquidation also requires a special resolution. And there are some resolutions which are ordinary resolutions but do need special notice, and special notice is 24 clear days notice rather than the normal 14 clear days notice. The one that you're most likely to come across is a resolution by the members to remove a director from office. I think all you need to remember about that is that red lights should start flashing if you see that. It's not the normal procedure, it's on special notice, and removing a director from office, if the shareholders pass the resolution to do that, isn't the end of the business, because there may be contractual rights and employment law rights that the director has got as well. So you really do need to take some quite specialist advice in a situation like that. Anyway, that is shareholder resolutions. As I said, the traditional way of passing shareholder resolutions is at a meeting of the members of the company, but the written resolution procedure is now, has been for decades, a legitimate alternative. Let's look first at meetings. And it is the job of the board of directors to call meetings of members of the company. It used to be the case that every company had to have an annual general meeting. Most companies are exempt, most companies do not bother. There are two categories of meeting. There's the annual general meeting, and then there's any other. And any other is known as a general meeting. Under previous Companies Acts, they used to be called extraordinary general meetings, or EGMs for short. The current version of the Companies Act just refers to them as general meetings. What if the shareholders want to pass a resolution and the board of directors are dragging their heels about calling a general meeting of the members? In that case, the members have got the right to force the issue. It takes only 5% of the shareholders to do that. And if, having called the meeting following the statutory procedure, the directors don't get on and actually convene a meeting, then the shareholders have got the right to step in and call the meeting themselves. It's important that the shareholders follow that particular process, and they start by demanding that the directors convene a general meeting. They can't just pass a resolution of their own initiative. They have to call upon the directors to set up a general meeting, and they then have to convene the general meeting themselves if the directors default. The members are entitled to 14 clear days notice of a general meeting, and the notice should also go to the directors, and if the company has an auditor, to them as well. Remember, there's a few resolutions that need special notice 28 days, and you should check the articles of the company just to see if there are any particular additional requirements about giving notice. You should send a proxy form and information about how to fill in and use a proxy form with the notice. And as with meetings of creditors, corporations have got an alternative way of being represented other than by using a proxy form. They can appoint a representative. Proxy forms have the advantage that the form is sent out with the meeting, and they're widely used and well understood. Appointment of a representative is a little bit unusual, so will risk causing a bit of confusion, but there are a couple of advantages that can be important. One is that the corporation attending by their authorised representative are considered to be attending the meeting in person. And that means that the representative could, for example, be appointed to chair the meeting, which could be useful. And also with a proxy form, the member would have to give advance notice of the appointment of the proxy. The board would be entitled to receive that notice. If a corporation is attending by a representative, they don't have to give advance notice to the board. The representative just turns up and produces their credentials at the meeting, and they're entitled to attend on that basis. When it comes to giving notice to the members, you need to know, of course, who the members are. And when it comes to counting the votes, again, you need to know who the members are. The Companies Act says that the register of members maintained by the company is the definitive record of membership of the company, who the shareholders are, what class of shares they've got, how many shares they've got, when they bought them. As you know, most companies do not comply with their statutory obligation to run a reliable register of members. So I think what many insolvency practitioners do in a situation like this, where they need to get winding up resolutions passed, for example, is to get a written representation and warranty from the instructing directors that gives written confirmation that you are entitled to rely on as to who the shareholders are and how many shares they have got. I've mentioned that companies law gets bits transplanted into it from time to time. Currently, we've got the Economic Crime and Corporate Transparency Act, or ECTA as it is known to its friends. One of the things that ECTA is going to do is standardise the contents of registers of members. I can't imagine that that's going to result in any more companies actually keeping a reliable register of members than currently do so. I did cover ECTA in a previous coffee break briefing as one of the important parts of it, the requirement for directors to identify themselves to Companies House, as that is coming into effect on the 18th of November. I might perhaps do a refresher on ECTA in the new year. Anyway, moving on from that, the Companies Act provision about notices is that they are deemed delivered after 48 hours if sent within the UK by first class post or sent by email. You don't count non-working days in those 48 hours. So if you send notice out at 4 o'clock on a Friday afternoon, the 48 hours won't start running until the next working day, and the notices will be deemed to be delivered at 4 o'clock the following Tuesday. And then the first of the 14 clear days notice will be the Wednesday. Do check the articles, they may say something different. Also have a look at what the articles say about electronic communications. Companies Act is pretty flexible about this, and the general principle in the Companies Act is consent, that as long as members are happy to receive stuff from the company by email or WhatsApp or whatever, then you can use that method to send formal notices to them as well. If you've got a shareholder who wants everything in writing on paper because they don't use computers, then you will have to comply with their wishes and send them stuff on paper. Although I've said that you need to give 14 days notice to the members, it is really useful that the members can consent to passing a resolution at a meeting that is held on short notice. And the short notice can be as short as you can possibly make it. So it can be, here's notice of an EGM, it's going to be held by Teams, here is the link, please log on immediately. And if the shareholders do that and agree to short notice, then you've got a validly constituted EGM, as long as everything else has been done properly. And to consent to short notice, you need a majority in numbers of the members, and those consenting to short notice have to have a huge majority of the voting rights. They've got to hold at least 90% of the voting rights, and that 90% might be increased to 95%. So really the safe rule of thumb is to look at unanimity for short notice. If you've got unanimity, if all of the shareholders agree to it, then you're in the clear. If there's going to be some dispute about it, then you need to look at the articles and you need to make sure you're doing it properly. Although auditors are entitled to receive notice of a general meeting, that doesn't give them the right to veto holding it on short notice. But holding an EGM, a general meeting on short notice, can be really important to get resolutions passed when you need them. And in terms of how you run a general meeting, first off, you need to appoint a chair who will normally be the chair of the board of directors or one of the directors, or if no directors are there and willing to act as chair, one of the members can chair the meeting. First thing the chair needs to do is to make sure the meeting is quorate, and you may need to check the company's constitution to make sure that you have got a quorum present. If you haven't got a quorum, you can't pass any resolutions. And then once you've got the quorum present, you then move on to dealing with the resolutions, the first one of which may well be agreement to hold the meeting on short notice. The chair will not have a second or casting vote if there is equal votes for and against an ordinary resolution, or if a special resolution is almost getting passed. Some older companies do still give the chair a casting vote, so again, check the constitution. And as with electronic communications, virtual meetings are allowed, physical meetings are allowed, a combination of physical meeting and virtual attendance is allowed under the model articles. It's really for the directors to decide how to set it up and how to run it. Key thing is make sure that none of the members are being excluded by however it is that you're planning to hold the meeting. So that's looking at meetings. Let's now look at the alternative to meetings, which is written resolutions. And the general principle is that a validly passed written resolution has the same effect as if that resolution had been passed validly by members at a properly convened general meeting of members. As with calling a general meeting, it is for the board to circulate the written resolution. As with a general meeting, if the shareholders want to pass a resolution and think that the board are dragging their heels, shareholders can force it. It takes the same 5% of shareholders to run that particular procedure. The notice, once sent by the company, will go to all eligible members and also to the auditors of the company, and there is statutory information about how the procedure works, how voting rights work, that have to be sent with the circulated resolution. And again, same rule for electronic communications work. It's probably going to be okay, particularly if the members who receive the written resolution electronically are content with that. Do check the articles just to make sure that those don't restrict the way that the company can run it. So although shareholders can force a resolution, they have to follow the procedure for doing it. They can't just pass a resolution and tell the board that they have done it. They have to follow the procedure of asking the board to circulate a written resolution, and if the board don't do that, the shareholders can then circulate the written resolution themselves, but they can't just sign a resolution and say to the board, look, we've passed this resolution. It doesn't work like that. There is a statutory provision in the Companies Act that says that procedural irregularities will not invalidate a written resolution. However, the courts have limited the application of that, and one example of that is the case of Sprout Land Holdings, where administrators were appointed, the court didn't like the fact that one of the members had effectively been excluded from the decision-making process. It wouldn't have made any difference. They were a minority shareholder. They couldn't have prevented it. Nevertheless, the court said the correct procedure has not been followed. Therefore, we will treat the resolution as not properly passed, which is a warning to us all. To pass the resolution, the members simply have to sign it and return it. They don't all have to sign the same copy. The resolution passes as soon as enough members have signed and returned it. And if it's an ordinary resolution, that means a majority of the members eligible to vote at a general meeting, 75% if it's a special resolution. So the process can be very, very quick. There is an expiry date. The resolution will lapse if it is not passed within 28 days. And if it lapses and the board still think the resolution can be passed, they will need to start the process all over again. So that's written resolutions. The final thing I want to talk about are sole members. And the general principle here from the Companies Act is that sole members can make decisions either of the sort that could be taken at a general meeting of the company's members, or that have the same legal effect as if agreed by the company in a general meeting. The Companies Act is very, very casual about the procedure for that. All it says is that the sole member can either set it out as a written resolution, which is definitely best practice, or having made the decision, they can then give the company details of it. Doesn't say very much about what those details should be. And the Companies Act then goes on to say that a failure to comply with that is a criminal offence. So you're going to have all sorts of money laundering and reporting obligations lighting up if you encounter this, but the decision itself still stands. Now, if you think back to some of these transactions that company directors can benefit from, which require shareholder approval, you might well have the director saying, well, of course, the sole shareholder approved that decision. No, there's no record of it. I didn't comply with the requirements as a director to keep a record of it or to tell the company would be made. And then you have this philosophical question of whether a decision has actually been made when there is no record of it, either in terms of a written record or in terms of actions taken by people as a consequence of that decision. And ultimately, you might find that that's a judge who has to make that decision as to whether the director is telling the truth, that the sole shareholder had made that decision. So this now brings us on to the summary slide. I'll just run through the points that we've been covering. We started by looking at company constitutional law, the company's rule book, its articles of association, the importance of model articles, which are often adopted as the company's rule book, and the fact that many of the rules come from the Companies Act itself. We looked at the division of responsibilities between directors and members in terms of the management and control of the company, and how there are some decisions which cannot be taken by directors. Those are decisions that are reserved to the members themselves, and the only way that members can make a decision is by passing a resolution in accordance with the constitutional requirements of the Companies Act and the company's rule book. Most resolutions are ordinary resolutions that pass on a simple majority. Some are special resolutions which require a 75% majority to pass them. And traditionally, to pass a resolution, members have had to hold meetings. Meetings can be virtual or real. They may be on statutory notice, but the members can agree shorter notice. A valid meeting needs to be attended by a quorum of members present in person or by proxy, and corporate members can appoint a representative to attend on their behalf. The meeting needs to be chaired by a director or a member. As an alternative to passing resolutions at a meeting, members can pass written resolutions. That can be done very, very quickly, but there are important procedural formalities that must be complied with to make it a valid written resolution. And companies that have a sole member can make decisions of that sole member very informally, and other companies are also able to make decisions informally under the duomatic principle, which is what I'm going to be talking about at next month's coffee break briefing, and that's on the 8th of December. Before I move on to these other dates, I see that there are a couple of questions, so I will have a look at those now and see what they are. There's a question here from Mark Hopkins on written resolutions. The context being that written resolutions are treated as passed when the required majority of signed resolutions return them. And the question is, presumably the date on which the 75% vote, that's 75% of those eligible to vote at an EGM, on which the 75% vote is signed and returned, that date is the date of the written resolution. Yes, that's correct. That is the date of the written resolution, is the date on which the 75% have got it over the line and notified. Then we've got a question as to whether the same person can represent more than one shareholder at a general meeting to make a quorum. Yes, they can, because if you've got one person who is proxy for two shareholders, then you've got two shareholders who are present by proxy. And it's also possible as well for a proxy to be given instructions to split the vote. So you can have a proxy who is representing one shareholder, and that shareholder's maybe got 10 shares, and they're saying, well, in actual fact, we're holding these shares as trustees, and 3 of our shareholders, 3 of our beneficiaries have said they want to vote for, and 7 have said voting against. So on our 10 shares, vote 3 for the resolution and 7 against. So that is also possible. But yes, one person acting as a proxy or an authorised representative can represent more than one shareholder at a general meeting to make a quorum. And final question is, if the articles still refer to an extraordinary resolution for a particular action, should it be passed as such, or do you pass it as a special resolution? An extraordinary resolution, from memory, is an ordinary resolution requiring only a simple majority, but on extraordinary notice, which is then 21 days notice, and it used to be 21 days notice for a special resolution. So I would think that the safest thing to do is to pass it as an extraordinary resolution in accordance with the articles, which would be to give 21 days notice, but pass it on a simple majority. And I think that's right. It's a long time since I've had to look at an extraordinary resolution. It may be possible to pass it on 14 days. I'm not sure offhand whether the statutory 14 days overrides what articles themselves say. I don't think it does, but I haven't checked that particular point. So I think that is all of the questions. Thank you for those. Dates for the diary. In addition to the coffee break briefing, there are 3 others coming up soon I'd like to remind you about. There's the R3 SPG forum. I think that is now fully booked, but I'll be going to it, so do say hello if you're there as well. There's the R3 Personal Insolvency Forum in London. I think there's still tickets available for that, and again I'll be going to that, so say hello at that one as well. If you're local, the date for the Southern and Thames Valley Regional Meeting in February is the 12th of February, and that is going to be at the Empress of Blandings at Copythorne, and there will be an opportunity to stay after the meeting and have a meal afterwards, which the last couple of years has actually been quite a lot of fun. Most important date there is Friday the 5th of June 2026, which is Fretton's 4th annual insolvency conference. Venue is going to be in the New Forest. It'll be a different venue from last year's, which was absolutely fantastic, and I hope to see many of you there. So anyway, thank you all very much for attending. I don't see any more questions, so thank you all very much. See you at the next coffee break briefing, if not before. Should have here contact details if you need to get in touch. There we go. And thank you all very much, and goodbye.